Hi, and welcome to Module 2 of the Training for High Fidelity Wraparound Providers Working in Wyoming's Juvenile Courts. Module 2 will cover abuse and neglect proceedings and is one of 6 training modules regarding high fidelity wraparound providers in Wyoming's Juvenile Court. Abuse and neglect cases are covered in Title 14 of the Wyoming statutes in Chapter 3, both Articles 2 and Article 4. Article 2 covers the Child Protective Services, the duties of DFS, Central Registry, and confidentiality of records. Article 4 is the Child Protection Act and the statutes relating to abuse and neglect proceedings. This diagram is an overview of the court process and the DFS process in an abuse neglect proceeding. As you can see, the blue arrow indicates what day, from day 1 through day 365. The light brown boxes on the top of the blue arrow indicate the DFS processes that are occurring during those timelines, and then they're matched up against the dark brown boxes down below, which is the court process. This is meant just as an overview. We'll be talking about all of the specifics of these things as we get through this module. The place we always start when talking about abuse and neglect proceedings is reporting suspected child abuse. Any person who suspects, has reason to suspect, or has observed conditions that would result in abuse or neglect shall report to the local child protection agency or law enforcement. This is Wyoming law. It is mandatory. This includes everyone, whether they are a provider, an attorney, a teacher, a neighbor. According to Wyoming law, everyone must report suspected abuse, neglect, or exploitation of a child or vulnerable adult if they have reasonable cause to believe that it may be recurring. Wyoming Statute 14.3.205 covers this law. Wyoming Statute 14.2.304 talks about how DFS must receive, assess, or investigate all reports of known or suspected child abuse or neglect. Within 24 hours after a report, they need to initiate an investigation or assessment into that report. And at initial contact with the respondent, they have to advise the person of the specific complaints or allegations made against them. DFS is also responsible for maintaining the Central Registry. This placement on the registry is separate and apart from the juvenile court proceedings, but is sometimes related or discussed during the proceedings. We discussed in Module 1 about one of the 3 ways a case ends up in juvenile court, being temporary protective custody. According to Wyoming Statute 14.3.208 and 14.3.405, temporary protective custody can be taken if there are reasonable grounds to believe that a child is abandoned, lost, suffering from illness or injury, or seriously endangered by his surroundings, or the child's conduct or behavior seriously endangers himself. When it's necessary for the best interest or welfare of a child, a court may order medical or other necessary health care, including mental health care and substance abuse care, notwithstanding the absence of a prior finding of neglect, meaning that the court can order for care of that child after protective custody has been taken and before a finding of abuse or neglect occurs. Many people believe that it's the Department of Family Services that actually takes a child into custody. This is not correct in Wyoming. In Wyoming, only a physician, physician's assistant, a nurse practitioner, or law enforcement may take a child into custody if there are reasonable grounds to believe that that's necessary. Once protective custody is taken, the person that takes it immediately notifies DFS, and DFS accepts physical custody of the child. This is why many people believe it's DFS that takes protective custody, because they do show up right after it's taken, but it is not DFS that does take protective custody. At that point, DFS must make reasonable efforts to inform the parents or guardians of what's going on, including the non-custodial parent. This date is the removal date for review purposes and the proceeding. DFS then places the child in the most appropriate and least restrictive setting necessary. When it's in the best interest of the child should be placed with non-custodial parent or the other family. Abuse and neglect children cannot be placed in jail or a detention facility. Then DFS needs to initiate the investigation, assess the child's mental and physical needs, arrange for their education, and if there's an MDT meeting held before any hearings, participate in that. This time of temporary protective custody cannot exceed 48 hours and is exclusive of weekends and holidays. The Department of Family Services has an intake and track assessment. So the intake and track assessment determines whether it's going to go into an assessment case or into an investigation case. It's an investigation case that usually ends up in juvenile court. They also prepare a shelter care or initial hearing report. They prepare a predisposition report and also a family service plan. DFS caseworkers communicate and coordinate services for the family and make recommendations to the court. The policies for the Department of Family Services can be located at the web address included on this slide. Intake is the first stage of this process. The DFS gathers information from a reporter and records it and identifies and locates the children, parents, or caretakers. This information that's gathered helps determine if the referral meets the statutory definition of child abuse or neglect, and also helps assess the seriousness of the situation. They also do a safety assessment, and this continues throughout the life of a case. There are collateral contacts that may be made for the purpose of assessing safety or clarifying and establishing the credibility of the referral, and also to determine the appropriate track, whether it's going to prevention, assessment, or investigation. The referral has to be rejected or assigned by the DFS supervisor within 24 hours and documented in the data system as to the reason for the track assignment. Accepted referrals are assigned an investigation track or assessment track, or a prevention track if there are no allegations of abuse or neglect, but there are risk factors and services to the family that could prevent abuse or neglect from occurring down the road. The investigation track is used when there are criminal charges appear likely, the children is in imminent danger, is likely to be removed, a fatality, major injury, and/or sexual abuse. The assessment track is used if the referral alleges abuse or neglect but does not meet the criteria for the investigation track. And again, the prevention track is used if there's no allegations of abuse or neglect, but there are identified risk factors. This is the juvenile court process at a glance that was introduced in Module 1. We'll go into more detail in this module about the hearings that are applicable to an abuse and neglect proceeding. The first thing is that we have a shelter care report. The purpose of the report is to provide necessary information on the case to the juvenile court. When a child is removed, the caseworker must notify the district or county attorney and provide the district county attorney, GAL, or public defender, and the parents, guardians with a report. The report shall list identifying information regarding the children, family, household members, and other important people, the physical and mailing address of the family, presenting situation, whether being in the home is contrary to the welfare or whether removal is appropriate, reasonable efforts that have been made, efforts to contact absent parents or relatives, information regarding the Indian Child Welfare Act, recommendations, and recommendation on placement where the child is. Then the county or district attorney files a verified petition. They have discretion to file an action, so if they decide at that point that there isn't enough to constitute abuse or neglect and file a case, then the child goes home and a proceeding never begins. This also has notice given to the appropriate parties at this point. Here is the definition of abuse and neglect from the statutes. This can be found in 14.3.202A, The first hearing in court, if temporary protective custody is taken, is a shelter care hearing. This must be held within 48 hours of temporary protective custody being taken. Written notice with the time, place, and purpose of the hearing must go to the child and the parent's guardian or custodian. At that hearing, the court determines whether shelter care is required to protect the child's welfare pending further proceedings. At this hearing, the court also needs to be informed if the child is potentially of Native American descent, so that they know whether or not the Indian Child Welfare Act applies. Wyoming Statute 14.3.409 addresses shelter care hearings. The next hearing that's held, or the first hearing if temporary protective custody is not taken, is the initial appearance. An advisement of rights is given to the respondents. They are advised of specific allegations. The rights that are covered are the right to counsel, copy of the charges, the right to confront and cross-examine witnesses, the right to introduce evidence, the right to present witnesses, and issuance of process. They're also advised at that point of their liability for costs of treatments and services. And sometimes they have the opportunity to admit or deny the allegations at that point. You can have a shelter care hearing and initial appearance held together or separately. And at this point, the case sometimes is held in abeyance by a consent decree, which we'll talk about in a few minutes. If the person denies, you go to an adjudication trial. If they admit, you can go to the disposition hearing. Adjudication is the court's formal ruling on the juvenile court case. It can be held by bench or jury. It's set within 60 days after removal of the child, and sometimes, if good cause is found by the court, that can be 90 days. Again, if they're adjudicated, you move on to the dispositional hearing, and if not, then the case is dismissed. This is oftentimes when people are comparing juvenile court to criminal court. This is where the parents are found guilty or not guilty, but in juvenile court, we use the words adjudicated or not adjudicated, because we're there to worry about the family and maintaining and reunification, not guilt. A consent decree is an agreement by the parties that the allegations are held in abeyance. This is similar in a criminal case where a first-time offender may have a period of time. They agree to do certain things for 6 months, and if they do it and complete it correctly, then that is taken off of their record. This can be revoked for failure to comply. It requires the consent of the district or county attorney, the GAL, and the parents in the neglect case. For a neglect consent decree, the statute limits it to 6 months of length, with only one 6-month extension if the child is an out-of-home placement. It must be in writing and must include a family service plan that the family is agreeing to comply with. A predisposition report is what the DFS caseworker completes within 30 days of a petition and prior to the disposition hearing. This summarizes the significant findings of the investigation and has a recommendation for a family service plan and permanency. A family service plan establishes measurable goals and steps that specifically address the needs of the entire family while incorporating the safety, well-being, and permanency of the children and youth. It's a document that's created in partnership with the family and in collaboration with formal and informal supports. It may be created during a family team meeting, an MDT, or other appropriate meetings. It is required for all open cases. It should be family-centered, strengths-based, individualized, culturally competent, comprehensive, reflective of community partnerships, and outcome-based. For non-placement cases, it has to be completed within 30 days of opening a case, and for placement cases, it has to be completed within 60 days of placement or change of placement. This is a screenshot of what the family service plan looks like. It's the first of 11 pages. The plan discusses caseworker, child, and parent responsibilities. It also includes goals and the permanency plan, a placement well-being checklist, case activities that must be completed, and a visitation plan. A full version of the Family Service Plan is included with the handouts for this training. Next is the dispositional hearing. This can be held immediately after adjudication or within 60 days after adjudication. Before placing the child outside of the home, the court has to find by clear and convincing evidence that to return the child to the home would not be in the best interest of the child, despite the efforts that have been made by the Department of Family Services. These hearings may decide questions such as the children's current living situation, who has legal custody, and what services the child and family may need. The duration of a dispositional order is indefinite unless it's sooner terminated by the court. It terminates at 18, although there are limited situations in which the court can extend that out to 21. If a child is in a placement out of home, the placement needs to be adequate, meaning that it's meeting its basic needs, the least restrictive, the least expensive, and the most educationally appropriate. This is from Wyoming statute. Additionally, appropriate treatment should be provided, the child should not be overly medicated, and proper discharge planning should be conducted prior to transition back to the community. If an out-of-state placement is required, there are specific findings that the court has to make. The court shall not order an out-of-state placement unless there's been evidence presented to the court regarding the cost of the out-of-state and in-state placement and whether or not an in-state facility is available or currently available. They must also have an affirmative finding on the record that no placement in Wyoming can provide adequate treatment or services for the child, and the court must state on record why no in-state placement is available. 6 months after removal or the date of the petition, a review hearing is held, and reviewing hearings should be held every 6 months thereafter. At this hearing, the court shall review the case plan to determine the health and safety of the child, the continuing necessity for placement, the appropriateness of the placement, what reasonable efforts have been made by the Department of Family Services, the appropriateness of the case plan and compliance with the case plan, the extent of progress toward alleviating or mitigating causes that necessitated the placement, and the date that the child is expected to be returned to the home or achieve permanency. This information is usually gathered and should be gathered when possible by a Department of Family Services caseworker testifying to these issues. Review hearings are covered in Wyoming statutes in 14.3, 431C. Next is a permanency hearing. These are to be held no later than 12 months from the date of the child's removal and every 12 months thereafter. This is in Wyoming statute 14.3, 431D. The purpose of the hearing is to determine whether DFS made reasonable efforts to reunify the family and whether a different permanency plan is in the best interest of the child. Permanency hearings are less common in other types of juvenile cases, but they can occur and are required, and they are different than 12-month review hearings. At the permanency hearing, DFS must present to the court efforts made to effectuate permanency plan for the child, address the options for permanency, examine the reasons for excluding certain permanency options, and set forth the proposed plan to carry out the placement decision, including specific times for achieving the permanency plan. Again, this information is usually elicited in court through testimony of the caseworker. DFS must also present to the court a compelling reason for establishing a permanency plan other than reunification, adoption, or legal guardianship. This slide shows the hierarchy of permanency options. This is established by federal and state law. Reunification is always the number one option for permanency. If this is not possible, the next preferred permanency option is adoption. After that is guardianship. And the last is APLA or OPLA, which is another or other planned permanent living arrangement. This is the least preferred option of permanency because it does not provide a permanent family for the child. Finally, just so that you are aware, parties have the right to appeal outcomes to the Supreme Court from juvenile court cases. So as we said in Module 1, this may occur in your case. You will not be involved in it, but it may occur while you're providing high-fidelity wraparound services to the family, which may delay the juvenile court proceeding. Thank you for listening to Module 2. Please note that there are 6 modules in this training, and we hope you'll listen to the rest.